no matter what the charter amendment did, the definitions and determinations that I got from all of the legal community was that you cannot be considered to remain impartial if you publicly speak to an issue on a zoning matter. Now, most of the zoning cases that we deal with are 2 feet of encroachment into the setback, or do they have 6 dogs when they're supposed to have 5 dogs, or something that's never going to go past the zoning hearing examiner and the appeal board. But when the Wal-Mart case came up, and I got letters from Wal-Mart with 30 lawyers listed on the side of that letterhead, the question came up, what's the consequence of council members speaking to these issues in CIM meetings, or publicly making statements in the press, or having emails? And the decision was, Wal-Mart and the developers of Eva Mar and other very large projects have the ability, the financing, the wherewithal, and the know-how to appeal our decisions to the circuit court. Not many of the cases do that. But the opinion that I was operating under, and the reason was, and the people that hear this and that aren't happy aren't going to be any happier. They're still going to be angry, and they're going to be emotional because they don't want it, and they're going to blame me and others for it. The reality was that the legal advice that I got down, and going to members of the Bar Association again, and lawyers again, and judges again, was that if these council members speak to Wal-Mart or these other issues, which we are allowed to do under those conditions of the charter, and it gets appealed to the circuit court, the judges are going to say, you cannot have made an impartial decision because you spoke and advocated and dealt with it publicly. So as a quasi-judicial agent of the Zoning Board of Appeals, how can the circuit court, the Court of Special Appeals, or the appellate court take your decision seriously? If you didn't recuse yourself, then you have prejudiced that case for every part of the appellate process that those cases go through. So my true intent, and you can take it or leave it, was to say that if I spoke out, and if I advocated, and if I made public statements, you lost your ability for protection at the zoning appeal board level, because I'd have to recuse myself, and my colleagues who did that would also. That means that that case goes directly to the circuit court anyway, without coming to us, because we have prejudiced ourselves publicly. Now that was the illegal opinion. That was the advice that I received over and over again. So in fact, if I'm naive or mistaken, it was done in the interest of what the law would permit and allow.